Involvement with the criminal justice system is life-changing. It matters.
Having a justice system that works is a really important part of a democratic society.
I'm Penelope Gibbs, Director of Transform Justice.
I'm Rob Allen. I've worked in and around criminal justice all my career.
This is the Transform Justice podcast, throwing light on the criminal justice system.
Hearing from people who know.
It's about whether the system's fair
and what can be done to make it better.
Hello. Recently we focused on the link between neurodivergence and crime. Today we'll discuss mental illness. Rob Allen and I are joined by two experts. Dr Bradley Hillier is a forensic psychiatrist with many hats. Rhona Friedman is a defence solicitor experienced in advocating for mentally ill clients. Rob, you do inquiries into near deaths in prison. Are these prisoners often mentally ill?
Well, in almost all of the investigations I've done, serious mental illness has been at the heart of the matter. That's both individual prisoners who've committed life-threatening acts of self-harm and nearly died as a result, and also cases where prisoners have nearly killed another prisoner. And in fact, in two of those, the prisoner who committed the assault is now in a special psychiatric hospital. They were transferred there afterwards.
Too late.
Too late.
Yeah. So can you give an example of the kind of case that you are looking into?
Well, I remember one of the first ones I did, a man in his 30s in Brixton Prison on remand. He'd been on antipsychotic medication, so he had been diagnosed as having a serious mental illness. When he got to the prison, there was no antipsychotic medication available for him. He deteriorated, kept getting into fights, was disciplined. His sister, his GP, his lawyer all wrote to the prison to say, look, this chap needs olanzapine, this particular drug that was really helping him in the community. He didn't get it. He tried to hang himself at the back of his cell and is still, as far as I know, in a vegetative state as a result.
Well, many years later?
Yeah.
That is a tragic case.
It was some time ago, about 15 years ago, and in response it's claimed that the system was improved, so it may well be better now. But I remember being quite shocked, really, that everybody was saying that this chap needed something relatively straightforward and he wasn't able to get it.
Bradley, should someone like that man be imprisoned at all, given how ill they were, or was the answer just the medication?
These situations always depend on the scenario that you're looking at the time. And we have a legal framework that does recognise the role of mental illness in offending in England and Wales, and that's developed over 200 years. But what we can struggle with sometimes is identifying the role or the presence of a mental illness at the time that somebody offends. What we try to do in the prison process now is to identify people at the point of reception through a screening process. But they're imperfect. It depends on how many people are coming through. It depends how busy they are. It depends on what information is shared from the court. And so you might have a prison like where I worked that had 1,200 people at one time with maybe 1.5 psychiatrists and 5 nurses. And that's the team to cover that prison. So the answer is obviously people who are really mentally unwell, prison is not a place for them. How you identify that person at the point at which those decisions are being made and get them out into a more appropriate setting is a bit more of a complicated question.
I mean, Rhona, in your experience, what effect do you think imprisonment can have on the mental health of people who are already ill and then end up being remanded or sentenced to prison?
Well, in my experience, nobody has improved mental health as a result of being imprisoned, particularly with the prison conditions that we experience now. It was very unusual when I first started my career to hear from your clients that they were locked up for 23 hours a day. And that is very common now, with no meaningful activity. And if you are struggling with your mental health, not having any distraction from that, not having any contact with people often, is only going to make things worse. And your medication story, I think it does still carry on. There is, for some members of prison staff, including the medical staff, a degree of skepticism, put it that way, about what inmates tell them in terms of their community-based medication regime. And if records don't catch up quickly enough, then the staff won't always take at face value what somebody's telling them about what medication was prescribed by their GP or by a community mental health team. So people are being suspected of drug seeking. Also, from the prison administration point of view, there's a resale value for some drugs as well. So there is a market, and people are medicating themselves with prescription drugs that they've bought from other inmates to get through, because our prisons are desolate, horrible, overcrowded places.
I concur with that. It's a very difficult balance to strike when you see a prisoner who's saying that they're prescribed a powerful antipsychotic medication that comes with all sorts of side effects and physical health concerns and other medications that may or may not be addictive as well. You have to make some very fine judgments sometimes.
Looking at an alternative to imprisonment, there was great controversy surrounding a decision last year not to imprison a mentally ill man, a man called Valdo Calocane, who pleaded guilty to killing 3 people in Nottingham. Can you take us through why he might not have been sentenced to imprisonment?
So Valdo Calocane had a diagnosis of paranoid schizophrenia, a severe and enduring mental illness. It's lifelong, there's no cure. His illness meant that he would go out of touch with reality. He may have hallucinations of things that weren't there. And one of the core features of this illness is it abolishes what we call insight. Insight being the appreciation that you know that you are ill and that your experiences arise from your illness. Now, criminal law in England, we do have the ability to take into account mental health issues in relation to somebody's offending and violence, and particularly in the case of murder, where the partial defence of diminished responsibility is available. So somebody can be mentally unwell to the extent that their ability to form rational judgments, exercise self-control and know the nature of their actions can be impaired. And the law has evolved to allow a court to reduce a charge of murder to manslaughter, which is important because a murder conviction carries an automatic life custodial sentence to prison, but a manslaughter conviction on the grounds of diminished responsibility opens the option of a court to, instead of sending someone to prison, they can send somebody to a secure psychiatric hospital indefinitely. And that's what happened to Valdo. And that decision was reached because several forensic psychiatrists assessed him. All of the experts agreed that when he carried out these homicides, he was sufficiently unwell that he should not be held fully responsible for them, and that the court should consider him going to a secure psychiatric hospital for an indefinite period. And there are lots of arguments for and against that, but there is a perception, and I don't think it's a fair perception, that people going to hospital are getting some sort of easier ride, or that it's a soft option. And I think that before people really put that view forward, they should probably think about what it entails to be under a secure psychiatric hospital for an indefinite period of time, to have to take medication that you may not want to take and that may be being injected into you at times.
I mean, Rhona, the families, not surprisingly, of the victims of Mr. Calocane were extremely unhappy with the sentence or the order that the court made. I think one member of a family basically said he'd got away with it. Do you understand that anger?
Absolutely. I mean, from their point of view, the loss and the violence of the way that their loved one was killed is just unimaginable. But one of the reasons we have a legal system is to remove emotion as much as we can from the way that people are sentenced and the way that they're imprisoned. This isn't a new kind of woke fix for people in the criminal justice system. This is something that's evolved really for about 200 years, that the English criminal justice system has recognised that insanity exists in defendants on very rare occasions. And I've had clients who have wanted nothing more than to avoid a psychiatric hospital order and would rather be in prison. The other thing to remember with cases like this, that if that person responds to treatment or the symptoms just abate by themselves, which can happen, a decision can be made to restore them into the prison community to serve a sentence, because there's a concern about bed blocking, and if somebody is well enough to serve a sentence, then back they go into the prison community. But it's very unlikely, I would imagine, that this particular individual will ever be deemed well enough to be out in the community. Very few people leave the highest level of psychiatric care once they've been put there by the criminal justice system. And the other thing to remember is it's a rare outcome that somebody who has killed in this way is found not to have understood the nature of their actions and to have been deemed so dangerous that they have to be in a psychiatric unit.
But it's also pretty rare for the victims' families to wage what has been quite a concerted campaign to get a different outcome.
Yes, that's true. One of the family members said that, he's got away with something, he's avoided prison. But how would he be managed in prison? Because he's just too unwell to be managed safely. You can't forcibly medicate somebody in prison. It's against the law. And so if he had been given a sentence of life imprisonment, approaching a whole life tariff would have been appropriate in this case because of the level of violence. So he would have been in prison for 40 years, perhaps even longer, as a management difficulty and a risk to himself and to other people in the prison community. It just couldn't have been managed safely unless you get to the point where you just lock people up in solitary confinement and go back to historic ways of dealing with people who are mentally ill in prison, where you just chuck the food through a hatch.
Lock them up and literally throw away the key.
Yes, exactly that. So I think that's the other way of looking at it. It's not an easy option to go to a psychiatric unit, and there's no other practical way of dealing with somebody like that.
Is there any argument for changing the law so that people in prison can be required to undergo the same sort of treatment
I think Bradley would have some real ethical concerns about that.
I think I can certainly speak for the majority of my counterparts who don't feel that prison is an appropriate place for the treatment of mentally disordered offenders. And it does raise major ethical considerations as to how we've conceptualised the idea of what mental health and problems with mental health mean in a legal context in terms of responsibility, how we as a society treat our mentally ill. Are we a society that imprisons mentally ill people, or do we treat them? Yes, there's a pragmatism of it. Sadly, we have long waiting lists to get people from prison to hospital. But is that an argument to treat people in prison, or is that an argument to make more places in hospital? So, I don't think that addressing the issue of ill people in prison by treating them in prison solves the problem. And these are quite serious medications. Even when we treat people in hospitals when they're very ill, we have to take real care, because restraining people can lead to problems with the airway, problems with breaking bones. And there have been lots of inquiries in hospitals where you have trained medical and nursing professionals to monitor the side effects, the risks, the sedation, the breathing issues, the unexpected muscle reactions and cardiac complications that can come from giving these medications, even in a medical setting. And you need to be able to respond to that. Prison is not a place to do that.
I mean, taking a step back in the process, Rhona, how can somebody who is suffering from a very serious mental illness participate fully in a Crown Court trial, say?
Well, we have criteria that people are supposed to meet to reassure everybody that they can participate fully. And if you've got concerns that a defendant, your client, isn't going to be able to participate fully, then you will instruct somebody like Brad to come along, in fact, two Brads, and assess your client to see if they can give instructions to their lawyers, can they give evidence themselves. Not everybody realises that they themselves, if they're the defendant, or that their client, if you're the lawyer, or the defendant, if you're the judge, isn't or may not be fit to plead. And I think a lot of people slip through the cracks, or there's a difference of opinion as to whether they're fit to plead. And if they're lucky, the judge will agree that they can have certain bits of assistance. They might have what's called an intermediary, which is a court-appointed helper to aid communication. What's interesting is that the Crown Court deals with these problems in quite a formal and formulaic way. But of course, most defendants in this country go through the magistrates' court system, where there isn't a formal fitness to plead process. And that can cause real problems for the judges in the magistrates' court as well as the defendant. So I think that the Crown Court is better as an arena for identifying those problems. And quite often through the cases that we've done, me and my colleagues, the first time that somebody is actually diagnosed and has funding to get an assessment is through the criminal justice systems. They might have gone through their childhood, their adolescence, possibly with mental health problems which nobody has ever taken the time to assess. And it's only when they get pitched into the criminal justice system that assessment has taken place.
Brad, could you give an example perhaps of a case where you have found, or the court has found, that somebody is so mentally ill that actually they can't face prosecution? And then what happens?
Yeah, so I've been involved in many cases where fitness to plead, as it's called, becomes an issue. And usually what the court is interested in having happen is what can be done to make this person fit, particularly if the charges are serious violence. Then the court is interested for people to become fit.
So this is for the sake of possibly the victim, if they're still alive, and their family, to try and get a process going. You're talking about pressure to actually get them fit. It sounds slightly odd to me.
Well, there's also something about the person who's accused of something being able to access justice themselves. So if the charges are often low level and there's a clear evidence of a mental disorder and that person is unwell at the time, one of the functions of these liaison diversion systems may be to present to the court that this is somebody who is known to mental health services and that the public interest may not be served by prosecuting this person, and it's much more pragmatic and sensible and recidivism reducing to link them back with their mental health team and to ensure that treatment continues. However, when the charges are more serious, for example, grievous bodily harm, I can tell you about a homicide that I was involved in of a man who killed and attempted to murder 2 people in the West London area a number of years ago. And this man was extremely unwell. I was asked to see him by his defence lawyer. And the aim at that point was to get him into an appropriate setting where he could get treatment. And so we arranged for him to be transferred under the Mental Health Act to Broadmoor. The aim, of course, was that in Broadmoor he would be able to get treatment and hopefully get better, and that the legal process would be able to continue with him being able to take a full part in it. As it happened, this man didn't get better, and so the court found him unfit to plead. It found him guilty of having done the act. But of course, they couldn't satisfy themselves in this case because he was unwell, that he had the guilty intent, as it were. And so he was sentenced to a hospital order, the same type of order as Valdo Calacane. And this is one of the cases that can be remitted back to the courts to consider if he becomes well at a later stage. So, for example, the argument that people might make, oh, he was just pretending to be sick, he was faking his illness. The backstop to that being the case is that if he suddenly became well once he got a hospital order with restrictions, actually there's a mechanism there to send it back to the courts.
Rhona, what kind of signs have you seen when you have got clients where you think, I think that they might not be of completely sound mind?
Well, I think if you start probing away and your client tells you that at various times they have a voice telling them to do things, or they hear strange noises, or that they feel that they're at the centre of a big story. So I had a client who thought that the planet was being visited by people from Venus, and he was privy to this huge secret, and there were various forces trying to stop him from bringing this to public attention, and they were pursuing him. So when you hear stories like that, very often that people are persecuting them, they have special knowledge. Those are quite good indications that somebody isn't very well.
Do you get those kind of conversations with people who haven't got a diagnosis of mental illness already?
Yes.
And they may not tell you either.
Yes, and I was just going to come on to somebody who had driven halfway across the country for reasons which he never divulged, and he ended up in a particular small village, and seemingly at random, he broke into a woman's house. Luckily, she wasn't there at the time. And he set various fires around the house. He had never met this woman. He had never been to that place before. And I think there was a slip once when he was starting to tell me a story which involved a conspiracy to kill the Queen. But he very, very quickly just retrenched from that, and the shutters came down, and he didn't want to talk about it again. And he never talked about that to any psychiatrist. We got 2 assessments done for him to see whether he was fit to plead. And so he was clearly unwell, but he wanted to conceal it.
And he had been concealing it from other people up until this point.
He had no previous psychiatric history, apart from a bit of therapy. In fact, he did get better and well enough to plead. And for him, that was the best thing, because he wasn't actually from the UK. He needed to go back home and be with his family and get treatment in his own language somewhere else. And that's exactly what happened to him.
I mean, Brad, when somebody like that is judged eventually to be fit to plead and a trial gets underway, does that mean that, in effect, they're deemed to be able to know right from wrong, know the effects of their actions, and so on, in the same way as someone without any mental illness, or does the process get adapted in some way?
So I think there are 2 concepts at play here. The fitness to plead concept is how somebody is at the time of the legal proceedings themselves. So if somebody becomes well enough and fit to plead, then that means they can participate in the proceedings, and they may have these adaptations. Like Rhona said, they might have an intermediary who's somebody who helps with communication. What the trial then is there to do is to look at the mental state at the time of the alleged offence. And these are the times when these so-called partial and absolute defences may also come up. The partial defence is diminished responsibility for murder to go to manslaughter in the way that we've spoken about. And then the absolute defence of insanity. So at the time of the act was somebody labouring from defect of the mind, I think, in terms of the language that gets used. It's still from 1843, that they did not know the nature of their act, or if they did not know that it was wrong. That's still our test.
And it's a very contentious test.
It's a very contentious test, and it's a very narrow test.
And you could quite often dance around on the head of a pin.
Absolutely.
So, for example, if somebody has an addiction problem, there can be a huge legal bun fight as to whether they're suffering from a disease of the mind or whether this is some form of voluntary intoxication, which has meant that for that moment or moments they weren't aware of what they were doing. And it can seem a very narrow difference, but huge in terms of the pathway that you can take in law.
But Bradley, you mentioned the partial defences, this idea of diminished responsibility. But I think you said that only applies in homicide cases.
That's right.
But surely there are many, many people who are charged with less serious offences for whom such a partial defence would be entirely reasonable and desirable.
Yes. So the diminished responsibility offence is special, and it really arose because the death penalty was the outcome if you were found guilty of murder. And before the abolition of the death penalty, there was a workaround essentially that meant that the judge could not give somebody a death penalty by finding somebody to have had diminished responsibility without actually abolishing the death penalty itself. However, we have a real flexibility within the English and Welsh criminal justice system for mental health considerations to be taken into account at the point of sentencing in particular. So if there are mental health factors raised as potentially contributing to the offending to some degree, there is a wide range of powers that are available to a judge to take into account that very concept without having to formally go through a diminished responsibility framework that exists specifically for homicide. An argument can be made to go down a mental health disposal route instead of a custodial sentence or a non-custodial criminal justice sentence.
But Rhona, looking even further backwards, there is this crime which is called assault emergency worker, which has a 2-year maximum prison sentence. And people have been prosecuted for that who've been trying to commit suicide. A police officer has come along and they have lashed out at them, not caused any lasting physical injury, but lashed out at them. And I'm assuming that that person has a mental illness because they're trying to kill themselves. That is prosecuted the whole time. I can understand what Bradley's saying about the sentence in the end being possibly different because that person's mentally ill, but should they be, being prosecuted so regularly for that kind of thing in the first place?
Well, I want to step even further back. There are rising levels of mental ill health. And I think one of the problems that the police have, and one of the problems that people have who come into contact with the police who are not well, is that the skill of de-escalation is not something that all police officers equally have available to them. So some police officers are good at calming people down, are good at de-escalating, and things can be managed in a way where there isn't going to be a need for physical contact. And I think that's a training issue and an aptitude issue, and that's something that needs to be taken much more seriously than it is. Secondly, I work with lawyers who do actions against the police, and very often where people have successfully contested an assault that they are alleged to have committed against a police officer, what has actually happened, and this is proved ultimately in a civil court when an action against police has been taken, is that they are the victims of an assault. And there is a concerted effort to flip the scenario and to turn it into an assault against a police officer. And I'm not saying that that happens all the time, but I do think we should acknowledge that it happens some of the time. And so this great explosion in the number of people who are being prosecuted for assault emergency worker, number one, it could be avoided. Number two, some of them are not true allegations.
Yeah, and I would say we did research, Transform Justice, and it did seem that a very high proportion were either mentally ill or neurodiverse. So there is something disproportionate going on there.
Yeah. Not just assault against an emergency worker being overused. I have stood in court where somebody has come to court from a London hospital having been charged with criminal damage, and the criminal damage has been caused in the process of them trying to take their own lives. And they've broken, for example, a shower rail. And there's one particular hospital, which I won't name, which is quite notorious for calling the police when their own patients have tried to harm themselves and using the fact that in the process they've broken something.
I think this is a really complicated and quite difficult area. I don't think that anybody who's trying to harm themselves should be charged with criminal damage. But having worked in a secure unit where you do have very violent people sometimes who are well with their mental health to the broadest extent, they can also still be antisocial. You know, and I've had colleagues of mine who've been seriously assaulted by inpatients who haven't got their own way about a particular thing. You know, like we're talking broken bones and, you know, people getting sustained injuries to their head and things like that. Now, one of the things that we have sometimes struggled with is actually for that to be taken seriously by the police as well. So we have this unusual situation where we're obviously caring for these people and they're our patients and we're trying to rehabilitate them, and they've been deemed to have less responsibility for what they've done in terms of their violence or whatever, to mean that they need to be in hospital and have treatment. But they're also still subject to the law of the land, even if they're in a hospital. So it's not easy, and there's lots of ethical positions you could take on this, I think.
Well, thanks both. I think that's perhaps a point at which we need to draw things to a close. It's been a fascinating and wide-ranging discussion. We could have gone on a lot longer, but we can't. So, Bradley, if you were Lord Chancellor or Health Secretary, what one thing would you do to try and improve the experience of mentally ill people in the criminal justice system?
So I would want to go with a preventative approach pre the criminal justice system, and that's through investing properly in the community mental health services and non-forensic psychiatric beds so that people can access mental health services earlier in their illnesses, and to have more intensive support and treatment in the community, which would be a well-recognised way of reducing the burden of illness to the extent that people end up offending.
Okay, thanks. Rhona?
Well, given that that ideal is a long way off, something that we've been working on is a holistic approach, because lawyers are very bound up with instrumental ends. There's a legal process that you have to kind of shepherd your client through. And just focusing on that misses the emotional support, the advocacy for that client in a number of different aspects of their life, which will target how they got involved in the criminal justice system, possibly how they can avoid being in the criminal justice system in the future, may help convince the Crown Prosecution Service to divert them out of the criminal justice system entirely. And so that's a crisis support worker or a holistic worker who can make those connections to get that client set up with services and to materially improve where they are in their life.
Okay, thanks. What about you, Penelope?
I would divert many, many more people with mental illnesses so that they're not prosecuted in the first place. I think if it's a low-level crime like criminal damage or, in fact, an assault which doesn't cause a serious injury, I think a lot of those crimes don't need to be in court. Rob, what do you think?
We're building 20,000 new prison places in this country. Funds have been found to do that. And given what we know about people who are in prison, surely some of that funding should be used instead to strengthen the kind of approaches we've been hearing about, the early interventions, the kind of psychiatric hospital provision that can be used to try and prevent things from getting worse. I think it's a real mistake to invest all of that money in prisons and not to expand the kind of areas we've been talking about.
Thanks, Rob, Rhona and Bradley. And if you'd like to find out more about our guests, including about Commons Legal, the innovative firm Roma runs, do refer to our programme notes. Thanks all for listening. Bye.
Bye.
Bye-bye.
Bye-bye.